Riveting trial taking place in Atlanta. A young father gunned down as he dropped his 2-year-old son off in the morning at preschool. The victim, 36-year-old Rusty Snyderman, a Harvard Business School grad and father of 2 who married his college sweetheart. And the man on trial for his murder is pleading insanity, claiming an angel who looked like Olivia Newton-John told him to do it. We examine his unusual defense tonight. And the man on trial
not guilty by reason of insanity.
This mass murderer.
Go with the insanity defense.
What is the purpose of the insanity defense? An insanity defense is based on the theory that most people can choose to follow the law, but a select few persons cannot be held accountable because mental disease or disability deprives them of the ability to make a rational choice. Such individuals need special treatment as opposed to prison. Punishment is not likely to deter future antisocial conduct of these mentally diseased individuals.
Previously, the insanity defense was only used to mitigate a sentence, but could not result in a not guilty verdict. But in 1843, the first recorded use of the insanity plea to prove one's innocence took place when Daniel McNaughton murdered Edward Drummond, claiming that he was told to do so. Based on this case, the American government developed the first of 4 rules to determine the standards for insanity.
The public's attention returned to the controversial insanity defense 69 days into Ronald Reagan's presidency, when he was attempted to be assassinated. His assassinator, John Hinckley, was not found guilty by reason of insanity. He remained confined to a psychiatric facility.
Many people are ill-informed on how uncommon the insanity plea actually is. Many Americans perceive the insanity defense to be widely invoked and commonly successful. In a 2007 study, psychologist Angela Blochel of the University of Wisconsin-Oshkosh and her colleagues found that college students estimate that the defense is used in about 30% of criminal cases and succeed 30 to 50% of the time.
I think it really is the defense of last resort because the public is extremely skeptical about it.
90% of the insanity defendants have been diagnosed with a mental illness. Large numbers of individuals who pleaded not guilty by reason of insanity could return to the streets due to advancements in psychiatric treatment. Accordingly, the public is less receptive to a not guilty by reason of insanity verdict because the length of confinement may be exceptionally short and a person released is able to exert all rights of a regular citizen, as the person technically has not committed a crime. Furthermore, defendants who are found insane spend as much or more time in state custody than their criminally convicted counterparts. The media may foster the notion that criminals get away with faking a mental illness only to be released and reoffend. However, the insanity plea is actually based on a long-standing legal tradition and is rarely successfully completed.
After the final verdict in 1982, there was a tremendous public outcry and backlash. Due to this occurrence, the government decided to redefine the guidelines and limitations for the insanity defense. During the 3 years following the Hinckley acquittal, Congress and half of the states enacted changes in the insanity defense, all limiting use of the defense. Congress in 9 states shifted the burden of proof to the defendant. 8 states supplemented the insanity verdict with a separate verdict of guilty but mentally ill, and Utah completely abolished the defense. During the reconstruction of the defense, the Insanity Defense Act of 1984 redefined it to apply in cases where the defendant was unable to appreciate the nature of the wrongfulness of his acts at the time of the offense. In other words, the defendant did not feel guilty or remorseful for his actions during the course of the action.
Absolutely not. I would not feel remorse for something I didn't do. I am not guilty for any of these crimes. I did not do anything in sexual nature. I did not come on to any.
Another change is limiting the use of expert witnesses, due to it being a battle of the experts prior to the change. The ultimate issue of insanity is now decided by the jury.
Not only are states free to develop distinct laws in the field of insanity, but under the Constitution they are encouraged to do so. States like Idaho, Kansas, Montana, and Utah don't even allow the insanity plea as a defense against criminal charges, which raises the question, should states be free to legislate with unfettered discretion in accepting or rejecting the insanity defense, or is insanity a constitutionally guaranteed option? Because the defense is used rarely, it only receives periodic review, most frequently after verdicts the public find shocking. After the Hinckley ruling, Congress in some states passed laws designed to strengthen the standards for insanity. In these states, instead of requiring a prosecutor to prove a defendant's sanity, the defense attorney must persuade a judge and jury that the client is insane. In order for a jury to determine an individual's sanity, certain tests must exist that are simple enough and easy enough for an average juror to comprehend and apply. Currently, there are 4 tests that can determine a person's sanity. The first test, the McNaughton rule, requires proof that the defendant could not determine between right from wrong because of disease of the mind. The second, irresistible impulse, tests if the defendant was unable to control his or her impulses as a result of mental illness. The third, the Durham rule, states that the accused is not criminally responsible if the unlawful act was the product of mental disease. The fourth and final test, the mental penal code, diagnoses mental defect based on whether the defendant understands the criminality of their actions or was unable to act within the confines of the law.
In popular media and fiction, the insanity plea is depicted as being a frequently used defense.
To see if I'm crazy. To see if you're competent to stand trial. Why, do you think that you're crazy? If I say no, I get the death penalty, right?
As mentioned earlier, in reality it is seldom used. In Law & Order and other shows, it is portrayed as leading to a more lenient sentence and as a way to escape from the responsibility of a crime. However, this is not the case. Sentences in mental institutions are generally longer than for prison. The defendant's loss of freedom is therefore more protracted than had they served prison time. Also, in fictional cases, the insanity plea is frequently shown to be a last-ditch defense. This would never work in real life, as it would have to have been the main strategy from the beginning of the defense for it to even have a chance of working. These depictions in fiction and popular media feed the misunderstandings about the insanity plea. Approximately 70% of insanity acquittals result from agreements between opposing attorneys, in which the prosecution agrees that society would be better served by placing the defendant in treatment rather than in prison. This means that many cases do not actually end up in court. However, here are 2 cases in which the use of the insanity plea was publicized and attracted public attention. One is the case of James Edgar Holmes. He killed 12 people and injured 70 in an Aurora, Colorado movie theater in 2012. His attorneys claimed that he suffered a psychotic episode and that for years he had mental problems. He attempted to plead not guilty by reason of insanity, but the jury rejected this plea. They recognized his mental illness, but deemed him sane at the time of the incident, therefore he was found guilty on all charges. The other case is of John DuPont, who shot Olympic wrestler David Schultz. Although he was convicted of third-degree murder, the jury agreed that he was mentally ill. He thus was to receive mental health treatment and would not receive a life sentence.
The insanity defense is still a controversial topic in today's society. The topic remains divided among those who believe in the legitimacy of the defense and those who don't. Although the defense is rarely used, we are still left with unanswered questions. Why do so many misperceptions about the insanity defense still exist? When only 1 in 4 cases are successful, is it worth pleading insanity? Why is there not a nationally accepted standard for determining insanity in court cases?